say that? I don't think he'd appreciate that.
The judges of the court.
Let me suggest to you, going back to the first recommendation on creating an interagency study group. As you're aware, I'm sure the governor created the interagency task force.
Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
We are privileged today, and have been during this term, to have Presiding Justice Michael Dillon from the 4th Department joining our court in the absence of Judge Titone. Kavanaugh versus Caypinar.
Ready, the court.
If Your Honor pleases, it is a familiar principle of law that when there's a multiple theoried action that goes to the jury and there's a general verdict, if one or more of the actions are subject to some infirmity, legal insufficiency, error of charge, then a new trial is warranted. I will briefly and rapidly rush over some of these points because I'd like to get to loss of enjoyment of life towards the end of the argument. And I argue that the question of Dr. Sutitahorn's responsibility on the second two theories that was submitted to the jury depends upon whether that he actually saw bleeding. If he did not see bleeding, then he could not be held liable for failure to admit. And there is no proof that he actually saw active bleeding, nor is there any proof that what he did or did not do was a departure from good accepted practice. While Mr. Frowley would attempt to say that anybody could say, well, if he didn't put the client back up on her feet and re-examine her, that was malpractice, but no expert testified to that, and that theory is insufficient. Similarly, with reference to the theory involving the failure to properly inform Dr. Swenson, there is no proof in the record that Dr. Swenson was not properly informed. In reference to the court's refusal to charge relative to the failure to admit theory, we took the position, and it was our principal defense at the trial. If Dr. Swenson said send her home, it was our position that she should have been, that at least were entitled to a charge to send her home. We didn't get that charge, and we accepted to the charge. I'd like to go on now to another point, a very significant point. During the course of the trial, somehow or other, plaintiff's counsel, unbeknownst to my clients, to my counsel, received a copy of a statement that Dr. Sutitahorn had given to an insurance carrier years before. We didn't even know it existed. And it surfaced at the trial. And the trial judge said it was privileged and therefore you can't cross-examine on that. Nevertheless, he cross-examined on it, and he had an absolute, complete, and total field day on summation relative to that. The appellate division said it was error. They said it was harmless, and that's the question. Was the error harmless or not? Was it harmless to cross-examine Dr. Sutitahorn on a privileged statement and then say it was harmless where it went to the very heart of credibility, Dr. Sutitahorn's credibility? Dr. Sutitahorn's credibility was the principal issue in the case insofar as all three theories that went to the jury were concerned. Did he insert his finger in the vagina? And we concede that that theory was proven prima facie, the other two were not. But yet, he said at the trial, that's not what he said. That's not what he meant. His credibility was an issue. Was there active bleeding on the second theory? He said no. Again, did you tell doctors on the third theory, did you tell Dr. Swenson everything that you knew? He said, absolutely. And he read right from the record, because it happened so many years ago, he didn't remember. Then they vigorously cross-examined him on a statement, and there is no indication, no suggestion that he refreshed his recollection from this statement. And it is our position that this statement was privileged, affirmed by the appellate division, and under these circumstances, to suggest that the very good issue in this case, the credibility of my client, Dr. Sotitohorn, which was destroyed by this statement, and further, he was absolutely chewed up on cross-examination, to suggest that that was harmless error, I submit, is improper. The appellate division says it was error, it was harmless, we say it is not. Now, you will note in the brief that we did go through the testimony, the actual summation. There was no exception to charge taken on the summation, and I'm not suggesting that the exception to the failure to that per se is a basis for error. All I'm suggesting is this, is I would want you to look at the way he used the statement on summation to suggest that the question of credibility was very significant, particularly when Mr. Frawley in his brief, to sustain some of the theories that he said, that there was a question, that he relies on the testimony of Dr. Sotitohorn. I'm suggesting to the court that under those circumstances, there was great prejudice to Dr. Sotitohorn to have permitted this cross-examination. Now, there's another point that I raised, and I just will mention it in passing. If perchance any of the points that I raise are not reversible error, this court has never passed on the question as to whether or not, in this era of contribution, you should send it back for a new trial on it with everybody. Though I've cited in any number of cases in our brief would say that if the courts do reverse with one defendant, it should send it back for a new trial as against all defendants because of contribution. Now I'd like to get to what some might call a burning issue. One, rather strange that it has never come up in all of the years of our jurisprudence until the last 2 years. 137 years ago, you decided a case which dealt with loss of enjoyment of life, and as far as I could see, in 137 years, you have never again had occasion to talk about loss of enjoyment of life. It's rather strange, but it happened. And yet, in multiple cases in the last 2 years, the question of loss of enjoyment of life as a separate element of damage, involving the questions of cognitive awareness, came up in 3 cases at the same time. Ruffino versus the United States, which your honors are aware of. You refused to take certification from the Second Circuit because of McDougall versus Garber. Now, McDougall versus Garber, your honors are aware, was decided last Tuesday, and in McDougall versus Garber, there was an affirmed finding of fact of cognitive awareness. So there's some question as to whether or not the issue will ever be raised. How did the issue of cognitive awareness get raised in this case?
Question is whether it's really raised,
That's what I'm going to get to.
or whether it's really here.
That's the question. That's what I'm about to get to. Nobody asked for it in the trial court. Nobody made a request to charge. Nobody took an exception for the failure to charge. And mind you, with, I guess there must have been 150 pages of brief in the appellate division, the word loss of enjoyment of life does not appear. It only came up in the decision of the appellate division, where the appellate division said, and this is where the issue probably is properly before the court. The question came up on the issue of excessiveness for pain and suffering for $1.5 million.
And the appellate division says that $1.5 million is really justified because of this one element as, among others.
Yes.
Couldn't it be read, the appellate division determination, as a make-weight, really?
Well, you could read it that way, I suppose, but that's not the way I read it. I read it, they're saying, well, we justify for a reason A, B, and C, and we also justify the result of $1.5 million because cognitive awareness is not essential to recover for pain and suffering. Now, if that is what they did, and that's the way I understood what they did, if that is what they did, then it is technically a proper question of law for review by this court, because this court will review damage questions where errors of law are involved. And it is our position that it really is before the court. And I suspect, and of course, one of the things that we never know is when you grant leave, why you grant leave. We don't have that way of knowing, so we presume that one of the reasons you may or may not have granted leave dealt with the questions of loss of enjoyment of life. Now, I think because of that, I'd like to discuss loss of enjoyment of life in the context of the law as it should exist in February 10th, 1988, here in New York.
Mr. Bernard, I'm still having difficulty with your response to the Chief Judge's question. I don't see how we get to the issue. We're reviewing the jury's verdict. The jury didn't have the element of...
Judge Kaye, I understand your problem because I have the same problem.
No, it's not Judge Kaye's problem.
It's the
your
court's
pro-
problem.
No, it's not.
It's my problem?
It's your problem. That's why I said to you twice before, how do you know it's really here before us?
The only way I know it's before you is by virtue of the decision of the appellate division, which justified its result because of that issue. I can't point to an exception to charge. I can't point to a request
But
to
as
judge.
Judge Kaye says, we have a jury verdict, and we're reviewing the evidence and the charge and all of the other elements which went into that jury verdict.
Yes, but do you...
This is not one of the elements that went into the jury verdict.
Oh, I'm aware. Then hopefully, then you granted leave for other reasons.
That's a mystery known only to us.
Oh, I'm aware.
And eventually you may find out some of them.
Yes, eventually. I know it's a...
Be thankful you're here.
Well, I'm very thankful I'm here.
Mr. Bart, on a serious note as well in that connection, there is a distinction, is there not, between this court reviewing an opinion, a writing, the reasons of a court, as opposed to the
result.
order, the adjudication, the result, the charge in terms of the rules of law that we're allowed to examine. Is there not?
But
And
Your
isn't that some of the problem that we all seem to be having with your problem?
Your Honor, please, there is absolutely no question that we have, all counsel for the defendants have tossed around this whole question as to what is the question of law for this court to decide? Or how is the question of law properly before this court?
How did you answer that?
We answered it only by saying that with the appellate division attempting to justify the result that they did, since it goes to the question of damage, it presents a question of law for review for this court. Otherwise, we now have a holding by the appellate division, and who knows what's going to happen. Follow that is to the effect that, well, now, loss of enjoyment of life may be considered as part and parcel of pain and suffering, and you can also consider it as an element of damage in determining whether or not there is or is not excessiveness, even though it never went to the jury.
Mr. Bard, your red light is on, but you know, you use the word holding, and I think part of the discussion is whether it's a holding or dictum or a make-weight, as the Chief Judge said, and that's one of the problems which is confronting me, certainly, and I speak only for myself.
I understand the red light. My clock says 12 minutes and 59 seconds.
Well, that's the clock that we go by. Thank you very much, Mr. Barr.
Thank you, Your Honor. Just one further statement, if I may.
Just a statement.
And it's a joint position of the defendants that I want to say. If you come to the conclusion that cognitive awareness is necessary, and if it's an appealable order, then we suggest you send it back to the appellate division. On the other hand, if you do, again, on the question of appealability, come to the conclusion that cognitive awareness is not essential, whatever we've said in our brief to the contrary notwithstanding, and if no other basis for reversal, then let's get rid of the case and affirm.
Thank you very much, Mr. Bard. Mr. Melito, Mr. Bard has used up 1 minute of your time, so...
It's quite all right.
You represent Dr. Caypinar, is that correct?
Yes, Your Honor.
Now, why shouldn't he be held responsible for picking someone like Swenson to cover his calls?
Well, first of all, Your Honor, he was not held liable for picking Dr. Swenson. There was no claim that he did anything wrong in having, or was in any way negligent in having Dr. Swenson answer for
But
his call.
Swenson was negligent, was he not?
The jury found so.
Right. Now Swenson would not have been there but for Caypinar's putting him in a position to be there.
That is correct. But he was there pursuant to a standard covering arrangement. I mean, the facts are not really in dispute on that. 4 doctors, Caypinar, Swenson, and 2 others, had a deal. One of the doctors would always be in the hospital on call in case any of the patients of any of the 4 doctors showed up and the doctor was not there to take care of them.
Well, this plaintiff didn't want to be treated, but this plaintiff wanted to be treated by Caypinar. And because of that internal arrangement, she shunted off to Swenson. And as a result of that, or as a result of Swenson's negligence, we put it to you that way, she's injured. Why should Caypinar say, not my fault?
Well, because under our law, as it's always been, each person is liable for their own negligence only, unless there's some pressing reason to hold someone liable for someone else's negligence. And there have been very limited exceptions to that. Obviously, partners or joint venturers, as a matter of law, are liable for each other. The other area that's developed in the law, and I don't think it's applicable here, is the area of ostensible authority or apparent authority or estoppel in a case such as Hill that this court recently had, or the Maduba or Lanza cases in the appellate divisions, where someone presents themselves to a clinic or a medical group and asks for treatment by the group, by the clinic, and the courts have held they have a right to assume that everyone at the clinic or at the group will be under the control of the clinic, and that whatever the secret arrangements among them are, that they can assume that they're all employees under the control, and therefore the clinic itself can be held liable for anything that any individual does. Those are basically the only exceptions, as far as I know, in this state. What we have here is a situation where a woman hired Dr. Caypinar to treat her. He was not there, and another doctor treated her. I guess what is troubling Your Honor, I guess, is she was not necessarily aware.
Not my problem.
What perhaps is troubling the court, forgive me, is that she was not aware. But I submit that's no different than any situation where the doctor you've hired is not on the premises or is not there, and another doctor treats you.
Well, then you can pick another doctor, you see. In other words, if I called Dr. Caypinar and I was told, Dr. Caypinar is not here, you'd have to seek another physician to treat you. Then Dr. Caypinar is not responsible. But that's not the response. The response is, Dr. Swenson is here to treat you.
That's true. Dr. Swenson treated her, and I submit, first of all, you have a perfectly valid cause of action against Dr. Swenson if he malpracticed on you. And this is no different than if she went to the hospital and none of her doctors were there, and some other doctor was there to treat her. Whatever...
Would the hospital be liable?
The hospital would be liable,
If
yes.
you went to the hospital to be treated in the hospital and they assigned a doctor to you and the doctor malpracticed, would the hospital be liable?
If you went to the hospital asking the hospital for treatment, you're back to the ostensible authority situation, where perhaps it would be a question of fact as to whether she asked the hospital itself for treatment and whether she could believe that anyone they gave her was
But
their
if the jury
employee.
decided the hospital was liable because of the fact that that was the doctor who was presented,
But Dr. Caypinar
I
would be
didn't give the
liable for that.
illustration, you did.
Exactly, but Dr. Caypinar, and then if I follow through on my example, under that scenario, why should Dr. Caypinar be liable? She didn't go to Dr. Caypinar's office. Dr. Swenson wasn't in his office. If you want to analogize the Hill theory to this, if she went to Dr. Caypinar's office and he wasn't there and someone else walked in and treated her, perhaps you can say, well, ostensibly he had the authority of Caypinar. She went to the hospital. She rushed to the hospital. She got there. She went to the emergency room. She was met by an employee of the hospital who then went off to the side and called Dr. Swenson, who was covering for her. Whether under that scenario the hospital could be liable, there's no reason for Dr. Caypinar to be liable. I think this, if you do uphold this finding, it's a complete break. It will be a total new theory of liability.
Ask a question about something that's troubling me on another point. That is, assume we should find that there's no respondeat superior relationship, no vicarious liability here.
Yes, Judge.
Because Dr. Caypinar is liable on other theories, why should we not affirm?
Were that the only error in the case, I would submit that at the very least, that affected the apportionment of liability. Dr. Caypinar, remember, was held 75% responsible, that is, 75% responsible for a large judgment against him, 25% of which was based on Dr. Swenson's liability. At the very least, a new trial on apportionment or a reapportionment.
But why shouldn't it be viewed as liability on the part of Dr. Caypinar as a unit for apportionment? He's liable for reasons A, B, and C. He's also liable for reason D, which happens to be the vicarious responsibility theory. Why does it make any difference? He's liable, and the jury has said he's liable for X percentage. So you knock out one, and he's still liable for X percentage.
I disagree, Your Honor. The jury found that 25% of his liability was based on the Swenson vicarious liability. If you take that away, you must diminish his liability.
Well, that could be possibly a basis for apportionment as between Swenson and Dr. Caypinar, but that isn't the question before us. It's apportionment between that unit and another unit, and perhaps Dr. Caypinar has some sort of a cause of action for apportionment, which may come on later, but that isn't the issue here.
I disagree, Judge. I think the jury was apportioning how much of the liability between Satitahorn and Caypinar. And in a sense, if you take away Swenson's negligence, that's not in the case anymore, and that element of negligence is out, and what's left must be divvied up between Satitahorn and Caypinar. And I submit mathematically you come out with a lower amount for Caypinar. But may I add one other thing? It's our position that there are other errors in this case, over and above that error, that warrant not only a new trial on everything, but dismissal of the complaint. The two other theories against Dr. Caypinar can be broken into two categories. One, failure to diagnose the placenta previa, and two, delay in performing cesarean section. The first theory, even if you assume there's a question of fact on whether he was negligent in not diagnosing it in the 2 office visits in the 2 weeks leading up to the birth, there was no proximate cause in this case. And in fact, I think the appellate division implicitly agreed with that, since they affirmed solely on the second theory, the delayed cesarean. Even had Dr. Caypinar diagnosed placenta previa, when Mrs. Kavanaugh went to the hospital, and she was met by Dr. Satitahorn, he performed, or allegedly performed, the internal examination before he called anyone. Had Dr. Caypinar made that diagnosis, it would have made no difference. He had already performed the internal, and that, in plaintiff's theory of this case, was the crucial departure which caused the premature birth, which caused the increased bleeding, and were it not for that internal examination, none of this would have happened. So whether or not Dr. Caypinar had diagnosed it didn't make a difference. And furthermore, when Dr. Satitahorn spoke to Dr. Swenson, he told him there was no bleeding. Dr. Swenson said, I was very suspicious of placenta previa, and if there was any bleeding whatsoever, I would have admitted her. He told me there was no bleeding, I didn't admit her. Again, whether or not it had been diagnosed was irrelevant.
Mr. Lito, let's talk like lawyers for a moment.
Yes,
Concerning this relationship. As I understand it, in order to have hospital privileges, there had to be an arrangement for one doctor to cover for another. So that in this instance, there certainly was a sharing of a mutuality of obligation. And if I remember my law of agency, this creates that kind of agency relationship between the two. Isn't that enough of a nexus to have justified the jury's verdict? Or the
Are you
charge of
speaking on the
court?
vicarious liability point,
Yes.
Judge?
Yes, I am.
I don't believe an agent, principal is liable for the negligence of an agent unless
I'm
the...
talking about the agency relationship where we talk in terms of some contractual bonding so that the charge would be justified and vicarious liability could be sustained.
If that's so, Judge, then every covering arrangement would result in vicarious liability. I mean, it's a common practice by doctors. Doctors cannot be everywhere at once. They rely on fellow colleagues to be there to treat people in their absence. Yes, it's necessary. It's necessary for society, obviously. It's necessary for the hospital. I don't see that that's a basis to hold Dr. Caypinar liable, as long as anyone who's treated by a covering doctor has the opportunity to sue that covering doctor. There's no public policy reason to extend the theory in this area.
Mr. Melito, you see no distinction in the fact that Mrs. Gonzales didn't even know that Dr. Swenson was treating her. She assumed Dr. Caypinar was treating her. Is there a material distinction there?
I submit not, Your Honor. I mean, obviously it's a fact that
Was
is...
she informed?
There's nothing in the record one way or the other on that. I don't believe it was developed. I think the judge submitted it to the jury actually as to whether or not she was informed as one of the elements that was submitted. She was not informed. Whether or not she was informed, it's our position, it's irrelevant, because what the courts have always looked at is the relationship, in a covering situation anyway, the relationship between the doctors, were they partners, were they joint ventures. They've never looked...
Significant to look at the patient also?
Well, I mean, it depends on what respect you mean that question. Yes, obviously one must look at the patient, but yeah, if she had gone comatose into the hospital, unaware of anything, and showed up, and some doctor treated her, does that make Dr. Caypinar liable? Because if someone had waken her from a coma and asked her who was treating her, she might have said Dr. Caypinar.
But that's not what happened, and I think what we're trying to pursue, perhaps, at least in adding to the questions Judge Kay and Judge Wackler is, isn't it a traditional and broad basis for the imposition of liability in the vicarious responsibility area when someone is held out to be in a relationship which would have, as it turns out, the victim, and that's why we have to look at the patient in this case, believe that that's so. Doesn't that make it relevant to the extension, to use your word, and I'm not so sure if it is an extension, of liability in this particular relational situation?
Well, my position is that there is no basis to extend it in this case. I think the concern for the patient's belief certainly is a valid thing to be thinking about, but I don't see, given that there is a doctor there, a known identifiable entity, who did the treatment, who can be identified, who can be sued. Just because one might say, well, gee, no one told her it was someone else treating her.
No, you understand, that question is not set out of any, sympathy for the patient. It's set out of a sense of the relationship as it may bear on a three-party situation, on the normal, analytical imposition of liability. That's the reason I think we're trying to search for that third party's understanding of the relationship.
Yes, Judge. I understand, but it's our submission that there is an entity there that can be sued, that can be responsible, who is in effect not relying on Dr. Caypinar, who is using his own medical judgment, his own abilities to analyze the situation and to treat. I don't see that that is a basis for vicarious liability.
I guess it's possible that a person wouldn't even know that another doctor had treated him or her.
Certainly.
Dr. Swenson is not a party to this case.
He was not, but on the other hand, he was in the medical records and was known long before the statute of limitations expired. It was a decision by the plaintiffs not to sue him. Had they sued him, this issue would never have come up, and rightly it shouldn't have come up.
Does it make any difference that he's exercising independent medical judgment, perhaps said on behalf of Dr. Caypinar?
Anytime a covering doctor does that, he does it on behalf of the other doctor.
And you think that's irrelevant to whether vicarious liability ought to be imposed?
Unless you want to say that a covering doctor is vicariously liable because but for the other doctor he would not have been treating, and he is acting on behalf of the other absent doctor, unless you want to go that step, which I submit you should not for the public policy reasons in Grady, which I think are more valid today than ever, I don't think it makes a difference. To just get to one other error in this case, which we submit warrants a new trial on all issues. One of the key issues was sonography. The claim was a sonogram should have been used, and that had it been used, it would have been diagnosed. This was 1974. The defendant's claim was sonography was new, not yet accurate, not widely used, and it was not necessary to use it. Plaintiff's claim was to the contrary. The judge in this case charged the jury that a doctor has a duty to keep himself abreast and to use new and changing diagnostic tools. Now, the PJI charge, supported by hundreds of years of case law, is that a doctor must use approved methods in general use. That's different from using new and changing tools. And I submit that by giving that charge to the jury, which was duly accepted to, the issue of whether or not Dr. Caypinar should have used a sonogram was taken away from the jury. And in essence, they were told he had to use the new and changing tool, and his defense that it was not yet in general use was removed from him. And that error, combined with the other errors, since my time is running out, that I've detailed in my briefs, warrants, at the very least, a new trial on all issues if you don't dismiss the complaint.
Thank you very much, Mr. Melito. Ms. Davia?
This is the argument on behalf of Brookhaven Memorial Hospital on liability issues, just to set this forth principally. We're relying on Dr. Thorne's argument with respect to liability. He's our employee. There never was a dispute to that effect. And hospital liability, which originally was in two areas, it arose out of vicarious responsibility for acts or omissions of Dr. Thorne, and also there were allegations and there was proof as to departures, possible medical departures on behalf of other employees of the hospital. They were submitted to the jury as separate questions, and the jury found in favor of the hospital as to the other employees. Now, the appellate division affirmed liability totally, and implicit in that finding was that they exonerated the hospital as to the other employees. So our argument is that the issue with respect to other employees has not been brought up for review, and in the event that there is a new trial on liability, that the hospital's liability would be confined to vicarious responsibility through Dr. Thorne. The remainder of the brief on behalf of the hospital gets into the questions of damage in the case, and I don't know if I can add anything more to what Mr. Bard has said to try to enunciate a law question based on loss of enjoyment of life for the court. But I
Well, you
can-
know what our problem is on that.
I-
We recognize,
no, you-
we
You
recognize.
recognize it's your problem. It's our problem and your problem, but I do feel that what the second department said in this case is inherently illogical, and that to leave that holding, I'm calling it a holding, on the books for future guidance would be very
Well, we
detrimental.
can do anything with words. We could, in a very brief memorandum, indicate that that was simply a make-weight and not the ratio decidendi with respect to the ultimate confirmation of the $1.5 million reduction.
Yes, of course, but if it stays on the books, then it's a guidance for future cases, and then you will have the logical conclusion is that you will have cases involving permanently injured plaintiffs who come before the court with severe injuries, but with the claim of loss of enjoyment of life. And in such cases where the person is so impaired as to be not cognitively aware, this case would serve as guidance because the appellate division has said that cognitive awareness is not relevant to the issue. They seem to be saying that, they are saying that loss of enjoyment is relegated to pain and suffering, but then they are saying, well, the analysis of loss of enjoyment is not concerned with cognitive awareness, and that's where we feel it's illogical and it does raise a law question for this court to decide. In the event of a reversal and a new trial on liability, we would like this court to perhaps set a guideline with respect to this issue for a future trial for the trial court. And from that standpoint, excuse me, from that standpoint, it raises a law question. The hospitals, let me go on. The question of loss of enjoyment, we feel, and distinctly entails an analysis of New York's public policy, as exemplified by the medical malpractice reform statutes. And what is the policy of New York, and is this holding adverse to it? We know that the policy has been since 1975 to decrease verdicts and to lower insurance rates and to perhaps provide better health care in the area of medical malpractice. And so therefore, the argument is that consistent with this public policy, loss of enjoyment of life cannot be a separately charged element, and that cognitive awareness is a necessary element. The basic precept that tort damages are to compensate and not to punish is what is in play here. There is no benefit to a plaintiff if he cannot perceive what he has lost, no matter how primitive his awareness is. And if this court were to hold that loss of enjoyment of life is, that the question of cognitive awareness is not relevant, then the question of compensation could be decided in a comatose case, a comatose plaintiff where they cannot perceive any benefit, and therefore it could result in a very exorbitantly high award, which punishes defendants and does not truly provide compensation. There's another point that is raised on damages that Mr. Melito did not have time to go into, and perhaps I should spend a few words discussing, and that has to do with the reinstatement by the appellate division of the award for loss of future earnings to Justin Kavanaugh. $740,000 was reinstated by the appellate division and should not have been. We submit that the question of law presented by this court is that it was based on pure speculation of the plaintiff's economist, which the jury accepted as a conservative figure because the court on a recharge compared it with a Census Bureau figure which was over $100,000 higher and which was not reduced to present value. And so this recharge was fully objected to, vigorously objected to by all defense counsel as not being based on present value, and the court was requested to mention this to the jury as a guideline, and the court did not do so and gave the figure to the jury. As a result, the jury seized on Mr. Seplaki's figure of $740,000 and made an award.
There's
And
no question that that figure was based on present value.
That was, yes, Mr. Seplaki's statement, yes, but his calculations are something that we feel was very inflated in this case. The way he calculated the figures and came to a decision that in 1992, a normal white male, having graduated from high school, would be making $30,000 or close to that figure, and in the year 2034 would be making somewhere upward of $150,000. Were very inflated figures, though they were stated to be based on present day value. If there are no more questions from the court.
Thank you very much, Mr. Vier. Mr. Foley?
May it please the court on
Isn't there an enormous area for mischief in this vicarious liability area? I would think that if this court holds that there is such under these circumstances, that doctors would be very foolish to provide for anyone to cover for them.
This was not the case of the standard covering arrangement that doctors normally have. This arrangement was a joint venture. The doctors had a quote-unquote covering arrangement for every single day, including weekends, days off, and vacation. They had a roster which they had prepared and had posted in the hospital so that the hospital personnel would know who was on duty on any one particular day. This was not, if I'm going to be on vacation, will you cover for me kind of a thing. This was a joining together, an agreement on the part of 4 different physicians to say, look, we want to get admitting privileges at this particular hospital. In order to get the admitting privileges, one of us has to be on duty for an entire week to answer to the hospital staff. So let's get together, get ourselves a roster, we'll cover each other every single day and be available to the hospital every single day.
So doctors in the future will sit down, if given that choice, and say, well, either we do that to get into this hospital and subject ourselves to this kind of vicarious liability, or we just don't have this covering arrangement.
Well, there's another alternative, and that is that you don't go as far as these particular physicians went. They went one step further. If they helped out on another doctor's case, and they came in and they helped out, and they spent a half a day or whatever it would take to help out in that medical situation, they wouldn't accept the fee. That was the testimony in the case. Even if they spent an entire day helping somebody out, they didn't use the word entire day, but even if they helped completely on a case, they wouldn't accept the fee. In that circumstance, now you're joining your losses. You may suffer a loss by taking care of somebody else's patient for a full half a day and not get a nickel out of it. So this is the classic sign of a joint venture. a burden of responsibility sharing the losses has now been taken on by all of them because they've agreed they don't accept fees even if they help out for an entire half a day or day, whatever it may take to cover that particular
If
circumstance.
they do accept fees, then they're partners and subject to vicarious liability.
Well, if they are disclosed to the patient, they come in and say, I'm going to be handling your case, and they charge them a fee, and the patient agrees to say, well, okay, you're going to be handling my case, then they're really not. But in this case, they went the one step further, even beyond that. They didn't even disclose this arrangement to the patient. They had this arrangement with the hospital such that the hospital believed that these people were working together as a group, because when Dr. Sutithorn went to the patient, he says, I talked to your doctor, implying that they were all together, and they were all together treating her. It's an undisclosed agency situation in that circumstance, raising the estoppel.
The insurance along with their malpractice insurance, haven't they, like building contractors?
Well, if they are going to run this kind of a group and hold themselves out to the public as a group,
Well, I'm not sure they held themselves out to the public as a group. They had an agreement to cover each other because the hospital required it.
well, they held themselves out to the hospital as a group. They had the roster posted in the hospital. And who developed this roster? The physicians themselves, not the hospital.
I would imagine it's a very common arrangement today, but none of them had any control over the treatment rendered by the other doctors, did they?
In this particular case, there is a joint control. In other words, Dr. Caypinar did not stand back and say, Dr. Swenson, you take over. He was involved in the making of decisions, Dr. Caypinar was.
Then he ought to be answerable for his choice, Dr. Caypinar. But Dr. Caypinar had nothing to do with telling Dr. Swenson, treat her this way, or give her this surgery, or this treatment or medicine or whatever, did he?
No, he did not. But
And then why should he be answerable?
well, he should be answerable for another number of theories. One, if you're a referring physician and you refer your patient to another doctor and continue to participate in the care of that patient, then you as the referring doctor are not completely off the hook even if the referred doctor does something wrong, because you're continuing on in the care of the patient. Dr. Caypinar didn't step away. He was in the process of caring for this
I
patient.
don't see how the patient's interests are advanced in any way by this rule of law you urge. The patient still can sue Dr. Swenson.
But not if she doesn't know at the time that she's being cared for that Dr. Swenson is rendering her the care.
Well, she's not going to sue him at that time, but if he's guilty of malpractice, she knows he treated her, she can sue him. Why shouldn't she sue him instead of making Caypinar defend for somebody else's negligence?
Because Caypinar can then turn around and say, well, I had nothing to do with it. It was Dr. Swenson who did it. He was the one who told you this, that, and the other thing.
Then why not simply sue Dr. Swenson?
Well, in this particular circumstance, you can say, well, if you have a joint venture and there are two of the four that perform certain services on you, why don't you just sue those two and not sue all four of them? As being vicariously responsible, you have the choice of suing any one of the vicariously responsible parties. And that's why, in this case, it was our understanding that there would be vicarious responsibility in this case. And not only...
I can see why you want it, but I can't see what public policy is served by it. The patient's rights are not diminished in any way if there's no vicarious liability here. She still has all her options to sue Dr. Swenson.
Well, if in the event that it was undisclosed who Dr. Swenson was, that she never learned who Dr. Swenson was, then you have a circumstance where somebody has to answer for the activities of Dr. Swenson. We don't know who Dr. Swenson is. If the vicarious responsibility under these circumstances applies, then you have the remedy for the patient. That's the public policy aspect. If doctors join together and, in this case, perform services as an ad hoc group, a joint venture group, then any one of those particular physicians should stand to answer for the activities of any one of those groups, because if you can identify that one person, then they should provide the remedy.
I don't understand you to say that the other two members of this group are liable too.
No, not unless you say that as a joint venture, they would all be held responsible.
I'd be very surprised if this day and age that a doctor could treat a patient in a hospital and the patient be unable to find out who it was that treated her.
Well, there are circumstances, Your Honor, that does occur.
Is that
Sometimes.
true here?
No, we know who was involved in this case. We know there was Dr. Swenson and we know there was Dr. Caypinar. There's no question about who the people are, but we're talking now, I think, strictly about the public policy aspect of the case.
Well, you seem to be fashioning a public policy for an extraordinarily exceptional and perhaps unlikely situation. And what concerns me is in response to the Chief Judge's question about the public policy, you seem to try to trim the rule down as tightly as you can, but it still seems to me end up on a slippery slope in terms of the breadth of liability that's going to be imposed, which would undermine the public policy in terms of the availability of medical care, because physicians will not want to do this and risk parsing whether this is one that fits within the liability schematic and those which might not.
Well, in this particular circumstance, I would say that there is a holding out of a joint practice. When she came into the hospital, her doctor was Dr. Caypinar. She was then told that I spoke to your doctor. The holding out had occurred through the hospital at that point, because the hospital believed, apparently Dr. Sutithorn believed, that these doctors on this roster were all together, and that her doctor was this group, because he wouldn't have said, I talked to your doctor, he would have said, I talked to Dr. Swenson, not to your doctor. There's no proof that he intentionally misrepresented who he was telling her he had spoken to. See, so apparently there was this holding out that they were working together as a joint practice. And recently, in a First Department case, I just refer the court to it, it's called Ruane against Cooper, 127 AD 2nd 524, when physicians practice together and hold themselves out as practicing as a group, it's the Meduba against Benedictine Hospital theory of holding out and estoppel. It's sort of, and they don't cite the Hill against St. Clair's case in that Ruane case, but it's sort of an extension of the Hill holding out or estoppel theory. And I would suggest that in this particular case, it is an estoppel type of theory in addition to the joint venture idea, which imposes vicarious responsibility on Dr. Caypinar.
I keep you with Judge Bellicose's question in mind as well with regard to the policy considerations. I would think that no matter how you might try to trim it or narrow it in your answers, nevertheless, we're bound by the questions as submitted to the jury.
Yes.
And the jury's response to those questions.
Yes.
Which are related to whether the hospital required the covering arrangement, whether Mrs. Gonzales had the opportunity to select who would treat her in Dr. Caypinar's absence, and whether the arrangement worked for the doctor's mutual benefit, even if there was no fee splitting. Now, I imagine that we would have to say that with those three criteria, there is vicarious liability if the answer is appropriate.
Yes. Yes.
No
And I
matter
would
how we
submit
try to resurrect or reconstruct it now, that's the test.
that's correct. That's correct. And I would submit under those guidelines that implied in those guidelines are vicarious responsibility axioms that have been established, agency theories, estoppel theories, that are applicable to this circumstance, and that's what I've been trying to elaborate on at a little greater length.
The only apportionment question that was submitted to the jury, I'm talking about apportionment vis-a-vis the plaintiff's recovery, was as between the hospital and Dr. Caypinar. Is that correct?
Well, then there was the apportionment between Dr. Caypinar and Dr. Swenson.
Yes, but as it was submitted to the jury and charged, was that to affect in any way the apportionment of the recovery as against the hospital and Caypinar?
Well,
You understand my question?
I'm not-
What I guess I don't understand is why that submission of a question wasn't really gratuitous as long as Dr. Caypinar is liable. on
I
some
would
other
submit that
theory.
it probably was superfluous because there were at least several other theories of responsibility upon which you could base responsibility against Dr. Caypinar, and you didn't have to get into the vicarious one.
It wasn't submitted in any way as affecting the apportionment of the damages against the two units.
That's correct. That's
So,
correct.
I
That's
guess
correct.
my question is, what if there isn't vicarious liability? Then what?
There are at least 2 or 3, maybe more, theories of responsibility under which Dr. Caypinar was held responsible. So individually, he is responsible under other theories, not the vicarious responsibility for the acts of Dr. Swenson. So it can be upheld on that ground alone, that there are
What's your
other
best
grounds.
case?
Excuse me?
What is your best case?
For that proposition?
The proposition which you now stand before us advocating.
I don't have a best case readily available, Your Honor, but I can submit a case. I will look it up and find a case.
You mean you've come all this way and you haven't got the case yet?
This particular question that's been asked is the first time that this issue has ever come up in the case. It has not been briefed, it hasn't been argued before today. It's the first time that this particular issue has been raised. Other issues that have been talked about have been spoken about, but not that particular issue that was just asked. So we haven't had an opportunity to address
On the
that.
general issue of vicarious liability, what is your best case?
Meduba, Grady, all of those cases that I've cited in my brief on the vicarious
You
responsibility
don't want to pick
issue.
one for us? Because there are those who may have read those cases which found that they weren't directly on point.
Well, we can talk about Lanza against Park East Hospital as being an estoppel vicarious responsibility case. The case of Irene against Cooper, which I've cited to the court, 127 AD 2nd, 524.
All right, fine.
I'd like to just very briefly touch on the arguments made on behalf of Dr. Sutithorn and on behalf of the other defendants concerning the loss of enjoyment of life. That issue is not before this court. I would submit that whatever was decided below was pure dicta. As a matter of fact, in the McDougall case, which was recently decided, and I would ask that at the end of this argument, in the event the court does not have copies of the full McDougall decision, I have copies with me that I would hand that up to the court. In McDougall, the court says that the holding in Kavanaugh in the appellate division was dicta. They use that word. I would submit that it is not a legal issue before the court. It was something used by the appellate division to explain their rationale in saying, well, even had the case been submitted on loss of enjoyment grounds, we could still support it under that theory. But it is not the way, that's not the way the court upheld the damages in this case. They upheld it on the ground that the injury itself was worth $1,500,000 in terms of pain and suffering. With regard to Dr. Sutithorn's argument that there is no proof that there was any bleeding in this case, well, there's quite a bit of testimony by Mrs. Kavanaugh that she was bleeding while she was in the emergency room. The circumstantial evidence is that had he been doing a careful examination, he would have seen all of this bleeding concerning which she testified. As far as the statement of Dr. Sutithorn being used, the appellate division held it was in error, but they also held that it was harmless error in the sense that they were satisfied that it did not affect the jury's findings. The credibility of Dr. Sutithorn, the rejection of his credibility, was not that crucial in this case because the fact that he inserted his finger into the cervix was established by 3 or 4 other witnesses, including Dr. Sutithorn's own expert who came in and said, yes, according to the record, he inserted his finger in the cervix. As far as the court allowing certain questioning concerning the statement, that's something that hasn't really been touched on, but the court did allow counsel to ask certain questions concerning this prior statement, and there was no objection to the comments made during summation as far as the experts that were called by the defense. So those particular errors alleged have not been preserved for review. As far as the concurrent responsibility of Dr. Caypinar and Dr. Sutithorn, I think I've covered that in my brief. There was proof that even had Dr. Sutithorn not done what he did in this case, there was a good likelihood that there would have been a miscarry because of the placenta previa. And the fact of the matter is he did insert his finger, and that he contributed to it as well. So there's concurrent responsibility. The issue of sonography was covered adequately by the court in its charge in many different respects. It was not just in that one statement that has been referred to by counsel. And as far as the loss of earnings issue, Professor Seplaki testified at length concerning his projections. His projections were reduced to present value. The issue of lost earnings was not raised by defendant in the appellate division. It was something that I raised in the appellate division. It was never responded to in the sense that they've responded to it in this court. As a matter of fact, they said, well, we could see that $500,000 would be good for loss of earnings, and now they're sort of like backtracking on that particular position. I'd submit that for all of those reasons that the judgment, the order in this case should be affirmed. Thank you.
Thank you very much, Mr. Foley. Doe versus Axelrod.
Ready for call.
Your Honor, I'd like to reserve 2 minutes for rebuttal in the
If you
case.
find it necessary.
Thank you.
Mr. Zwickel, every now and again, a case comes along and you look at it and you say, this case doesn't belong here. This looks to me as though you have what would amount to something close to an interlocutory order, and we can't have people jumping into court every time there's an evidentiary ruling they don't agree with. Isn't this a case which would lend itself to the classic remedy of an administrative appeal after a final determination through an Article 78 proceeding or some court review in that context?
Your Honor, the answer to that, of course, is absolutely yes. The Commissioner, in his brief, in his first point, argues that the doctrine of exhaustion of administrative remedies applies particularly to this case and this set of circumstances, where what you have here is an issue which is not independent of the proceedings. It's not a severable constitutional claim, but rather it is part and parcel of the administrative process. And in fact, it's very obvious that regardless of which way this court would rule, if it were to rule on the merits, that the administrative process would continue. The matter would go up to the Commissioner, it would go back to it would go up to the Board of Regents, and judicial review would be available, and the issue would be preserved for review. So that it is our very first point that unlike those cases, those exceptional cases where this court and the lower courts have held that there are exceptions to the doctrine of exhaustion, those cases are clearly distinguishable. In virtually all of those cases, as far as our research disclosed, the constitutional issue or the abuse of authority issue was a severable claim, and if the party was successful on that claim, it would generally render the administrative proceedings inapplicable. This, of course, is not the case here. We know that the issue of cross-examination will be an issue that will be preserved and raised. In fact, one of the things we argue, which I think is absolutely correct, is that it would assist the court to have the hearing continue. Because one of the questions on the scope of cross-examination is whether or not the petitioner was able to have cross-examination to a reasonable extent. And it seems to us in particular, although we don't feel that there is a denial of cross-examination, and we'll get to that, but it would seem that having a full factual record on that matter could only assist the court. At this point, the issue is premature, and it was raised because the commissioner issued a ruling which the petitioner certainly didn't like. On the other hand, I think the basis for the doctrine of exhaustion of administrative remedies has always been twofold. One is the development of expertise within the agency, and secondly, an orderly process of government. I think that to encourage these sorts of collateral piecemeal appeals really undercuts the orderly processes of the professional conduct proceedings. I think it delays the proceedings, and I think it certainly is not only bad for society, but I think it's bad public policy. So that is essentially our first point
I
on
thought
this
I could
case.
save you a few minutes by making it for you.
All right. Well, thank you, Your Honor. I'm sorry. I hope I didn't go into it at too much length, but it is certainly a central point for us in this case.
Is a response to that, to prolong this a bit, however, that there may be some issues which are so fundamental, even in the administrative process, like a commissioner or the head of an administrative agency interfering with the independent quasi-adjudicative authority of an individual who wears a couple of hats, maybe, in the sense of they're fulfilling a responsibility as a subordinate, but it's supposed to be independent. If that issue cuts so fundamentally, is there no recourse other than the ultimate review that you would hold us to?
Well, I think the answer to that has to be yes, that there is no recourse. Because even if you review this court's prohibition decisions, which this has been analogized to some extent, in those cases, the court virtually accepts the principle that there's a fundamental constitutional or abuse of the power claim. And then it goes further than that. It says, not only do we have to have that issue present, but we have to have other factors. There has to be no adequate remedy at law. We look at the discretion of the judge, and we look at various other factors. And in the prohibition cases, of course, one of the underlying issues is that if there's a determination on that issue, it will essentially make the proceeding inapplicable. We use the word moot. I think the